Kelo versus City of New London is one of the most controversial and also one of the most widely hated decisions in the modern history of the Supreme Court. It addresses the question of when the government is allowed to use eminent domain to take private property. The Fifth Amendment says the government may only take private property for, quote, a public use. But for 200 years, really ever since the founding, there has been a debate about what public use means. Some argue that public use should be subject to what I call the narrow definition of it. That is, there is only a public use if the property that the government condemns is used for a publicly owned project, such as a road, for example, or alternatively, if it is transferred to a private owner that has a legal obligation to serve the entire public, like a public utility, for example. But on the other hand, there's also the broad view of public use, which says that a public use can exist anytime the general public might benefit from the new use of the condemned property in some way. And often advocates of this broad view say that the government doesn't even have to prove that the supposed public benefit actually exists. The City of New London, Connecticut, sought to condemn some 100 properties for the purpose of building facilities that were going to be done in conjunction with the construction of a new headquarters by Pfizer Inc. And 7 of the property owners involved resisted the condemnations. They went to court. They argued this is not for a public use because the property will be transferred to a private interest just to promote economic development. And the Supreme Court, in a closely divided 5-4 ruling, said that you can transfer private property to a new private owner simply on the theory that the new owner is going to do more for economic development in the area than the old use of the land would do. The majority made a couple of different points to justify their decision. They said first that there was previous precedent which endorsed the broad view of public use, which is true, there was. The majority also claimed incorrectly that their position was backed by precedents going back 100 years to the late 19th and early 20th century. As it turned out, this is not actually true. And Justice Stevens, the author of the majority opinion in Kelo, eventually had to admit that he had been wrong about that. Furthermore, they claimed that it's not a good idea for courts to be involved in trying to figure out whether a project really will produce a public benefit or not. In this case, consensus was shattered, partly because there was a close 5-4 decision with powerful dissents by Justice Sandra Day O'Connor and Justice Clarence Thomas. There are, I think, serious weaknesses to the majority's logic, even though they are right, at least in part, about the issue of precedent. One is that if you look at the text and original meaning of public use, there is much more evidence that most people and most expert commentators then supported the narrow view of public use than the broad one. If you're a living constitutionalist, you also have some reason to be critical of the Kelo decision. There's a lot of evidence that these kinds of takings for private purposes are historically used to harm the poor, the disadvantaged, and minorities for the benefit of powerful private interests. In the aftermath, 45 states passed eminent domain reform laws to try to constrain these sorts of takings, and that is a record. No other Supreme Court decision has ever generated so much new state legislation in response. It is also the case that several state Supreme Courts in the following years issued rulings saying that under their state constitutions, these kinds of economic development condemnations were illegal, even if they were permissible under the federal constitutions. It's worth noting, however, that the critics of the New London Development Project turned out to be correct on at least one point, and that is that it was a very badly conceived project that never actually produced any development. To this day, 17 years after the Supreme Court's decision in 2005, nothing has actually been built on the condemned property. The only users of it are a colony of feral cats. But other than that, no economic benefit of any kind has been produced by these takings, which is a tragedy for the people involved and for the community as a whole.